We're now recording.
All right, thank you, Louisa. Good morning. This is Brandon Stallings, Chair of the Board of Trustees. You are joining us on our July 18th, 2024 Executive Committee meeting. Going to call this meeting to order and ask our Board Secretary, Louisa Arpetian, to take roll call.
One moment, let me just promote Melanie. Okay. Chen, not present. Cisneros,
Here.
Good,
Here.
Shelby,
Present.
Soel,
Present.
Stallings,
Present.
Tony,
Present.
Trejo, not present. You have a quorum.
All right, thank you. Welcome, everyone. We're going to get right to it with our call for public comment. And as you well know, State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those of you attending via Zoom, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now, and State Bar staff will call on you in the order that hands are raised. For those of you who are participating via phone, you may virtually raise your hand by pressing *9. That is the star key, the number 9, and doing so will alert staff that you'd like to make comment, and State Bar staff will call on you and open your microphone so that you can address the board. For those who are participating from a noticed location, please alert the State Bar staff member present in the room that you would like to make a comment. Due to time restrictions, we cannot allow more than 3 minutes for each speaker. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 3-minute countdown will begin as soon as you start your comment. The on-screen timer will flash out the final 10 seconds. And it does not appear that we have any advanced sign-ups for Board Executive Committee. Is that correct?
That is correct.
All right. And Louisa, could you identify, or have you been able to identify any members of the public wishing to address this body?
Yes, we have the first speaker, Ray Hayden. Give me a moment.
Thank you very much. I just want to ask it if it's more appropriate for when the main meeting starts to make a public comment on 6.2.
Yes, that way you would be able to address the full board, but it's up to you.
Excellent. Have a great meeting, and we'll see you then. Bye.
Thank you, sir. All right.
Next we have Todd Hill.
Mr. Hill?
Esteemed members of the committee, thank you for giving me the opportunity to speak today. My name is Todd Hill, and I come before you as a former student of People's College of Law, PCL, to share my experiences and concerns about the state of legal education. I've authored a document titled Degrees of Deception When Legal Education Fails, which I hope will shed light on critical issues that need your attention and action. The pursuit of a law degree is often seen as a noble endeavor, a path to justice, and a means to advocate for those in need. However, when the institutions responsible for educating future lawyers fall short of their obligations, the consequences can be deeply troubling and far-reaching. My experiences at PCL highlight several areas where improvements are urgently needed. The document I present outlines issues such as alleged deceptive practices, misrepresentation, and challenges in providing quality education. These problems are not isolated incidents, but reflect broader systemic issues that affect many students, particularly those from marginalized communities. High attrition rates and low bar passage rates among these groups underscore the need for more supportive and equitable educational environment. The State Bar of California's policies and oversight play a crucial role in maintaining the integrity of legal education. I believe there are opportunities for the State Bar to enhance its support and protection for students, ensuring that all educational institutions meet high standards of transparency, accountability, and quality. Degrees of Deception is not just a recounting of difficulties. It is a call to action for constructive reforms that can restore trust and integrity within our legal education system. By addressing these issues, we can create a more just and equitable pathway for all aspiring attorneys. I urge you to review this document thoroughly and consider the implications of these challenges. Together, we can work towards meaningful changes that uphold the values of justice and equity in the profession. Thank you for your time and consideration.
All right, thank you, Mr. Hill.
We do not have any additional members who wish to address the committee.
All right, we'll close public comment and move on to Chair's report, which I will defer to the full Board of Trustees meeting. Move on to item 2, which is our open session minutes. This is approval of May 16, 2024 Board Executive Committee open session minutes. Are there any corrections or modifications to the open session minutes? All right, seeing no one raise their hand, may I have a motion to approve in a second?
I'll move the minutes.
All right, first by Trustee Sowell, do I have a second?
Second.
All right, and a second by Trustee Good. May I have a roll call vote, please?
Chen, not present. Cisneros?
Aye.
Good?
Aye.
Shelby?
Aye.
Sowell?
Aye.
Tony?
Aye.
Trejo, not present. Stallings?
Aye.
6 ayes, 0 nays. Minutes are adopted.
All right, thank you. We have nothing on consent. We have one item of business, and that is item 4.1. This is approval of annual appointments of officers and members of state bar sub-entities. And to present on this is our secretary, Louisa Arpetian, who is doing a lion's share of the work so far today. So thank you for being that batting cleanup, so to speak, this morning.
Yes, thank you. Good morning, committee members. This agenda item presents the candidates recommended for appointment to various committees for the upcoming committee year. Annually, the State Bar recruits diverse candidates, including attorneys, public members, and former and current judicial officers to serve on its committees. From January 16 to April 16, 2024, our appointments team launched a targeted recruitment campaign engaging with nonprofit, community, specialized, and local affinity bar organizations. Our multi-module outreach included direct email, social media, and personal outreach efforts. You can find a comprehensive summary of our recruitment activities in Attachment J. This initiative resulted in 177 applications consisting of 141 attorneys, 10 judicial officers, and 26 public members. I'd like to just take some time to express my gratitude to the board appointments liaisons, Chair Stallings and Trustee Barahona, for their dedication, support, and substantial efforts they have made in collaboration with the appointments staff this year. I'll now turn the discussion over to Chair Stallings and Trustee Barahona for further details, and I'm going to check to see if Trustee Barahona is here. I'm not seeing Trustee Barahona present at the moment.
All right. I'll offer my brief comments. I think the agenda item really speaks for itself as to the outreach that was conducted. The volume of applications that were received was fairly substantial for the number of open positions that we had. And I think both myself and Trustee Barahona were struck by how well qualified all of the applicants are. So during our discussions, we tried to keep a couple of things in mind. One is for some organizations or sub-entities, there's a desire to bring new blood on board, fresh ideas. So that was one of the things we had in the back of our mind. And then second was furthering our diversity matrix and looking at all areas of diversity and trying to make inroads as best possible. I have no further comments and would just open this up to any comments or questions from members of the executive committee. Okay, and has Trustee Barahona joined us yet?
I'm not seeing them
Okay.
in attendance.
And I'll give Trustee Barahona a chance to make any comments if they like in the full board agenda. It is, if it does pass out of executive committee, it will go on consent, so we can just pull it at that point. If there's no further questions or comments, can I have a motion?
Move to adopt appointments.
Second.
All right, first by Trustee Tony, second by Trustee Shelby. May I have a roll call vote, please?
Chen, not present. Cisneros?
Aye.
Good?
Aye.
Shelby?
Aye.
Zoel?
Aye.
Tony?
Aye.
Trejo, not present. Stallings?
Aye.
6 ayes, 0 nays, motion carries.
All right, and in line with this agenda item, I just wanted to comment and make a couple of thank yous at this point. First of all, special thanks to Trustee Shelby. And one of the things that you have done since the very beginning of your board service is to make sure that public members have a continued voice and a stronger voice at the State Bar. And you worked closely with staff to refine and to expand the way that we reach out to non-attorney members. So thank you for your continued work in that. And I just want to express my gratitude for each individual who applied. If you were not selected, please don't take that as a slight, and I hope that you will reapply in the future. We do have an embarrassment of riches here in California, and I'm always humbled by the amount of people who wish to invest back into the legal profession as volunteers, both attorneys and non-lawyers. The legal profession truly is stronger because of the work of every single one of our volunteers and the countless hours that you invest back into California. Special thanks to my fellow appointments liaison member and first-time appointment liaison member, Trustee Barahona. It was a pleasure to work with you, and of course, all the credit goes to our board secretary, Luisa Arpetian, and just the, again, countless hours it took to compile all of these applications, to vet candidates, to assist Trustee Barahona and I in our vetting of the candidates. And this really is a gargantuan task. So thank you to you and to the staff who worked with you on this. All right, that concludes our executive committee meeting. And so we will adjourn into the full Board of Trustees meeting. We'll have a couple of minutes to set up, and we should get rolling right at about 9:20. All right. Thank you, and welcome to our July 18th Board of Trustees meeting. This is the full board meeting here this morning in LA. We're joined remotely by several attendees. And if I could ask our board secretary, Luisa Arpetian, to take a roll call.
Barahona?
Present.
Buenaventura?
Present.
Chen?
Present.
Cisneros?
Here.
Good?
Here.
Grande? Huser? Shelby?
Present.
Soel?
Present.
Stallings?
Present.
Stevens?
Present.
Tony?
Present.
Trejo, not present. You have a quorum.
All right, thank you. Next on the agenda is call for public comment. For those of you participating by Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom of your screen. If you wish to address the board, please click on the hand icon now, and State Bar staff will call on you in the order that hands are raised. For those of you participating via Zoom, you may virtually raise your hand by pressing *9. Doing so will alert staff that you would like to make comment, and State Bar staff will call on you and open your microphone so you can address the board. Due to time restrictions, we cannot allow more than 3 minutes for each speaker. Please note that staff will have an on-screen timer visible to all attendees during the duration of your public comment. The timer's 3-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. And see that we have 4 individuals who signed up. So Louisa, if you could identify them and activate their microphone.
Yes, thank you. The first speaker is Lauren Klein.
All right, Ms. Klein, good morning.
Good morning. Good morning, everyone. My name is Lauren Klein. I'm the Director of Advocacy at the Legal Aid Association of California. I'm here to comment on agenda item number 6.4, approval of interest on lawyer trust accounts grant distribution for 2025. My organization, LAC, represents the statewide network of nonprofit organizations that provide free civil legal services to low-income people and that utilize funding administered by the State Bar to do so. LAC also acts as a liaison to the Legal Services Trust Fund Commission and participates in all meetings of the commission and their committees as they do their grant making. I'm here today to ask you to approve the 2025 grant distribution of $252 million recommended by the Legal Services Trust Commission. We'd like to express our gratitude to the staff of the Office of Access and Inclusion and to the Legal Services Trust Fund Commissioners for the hard work and thoughtful consideration they've put into this year's recommendation. To arrive at this recommendation requires careful forecasting of IOLTA revenue and consideration of many variables. Having personally observed this process for many years, I'm confident that this year, despite a higher than usual forecast, that the staff and commissioners have responsibly considered the available information and are prudent in their recommendation. I can also confidently report that the legal aid organizations are prepared to receive this funding and to provide much needed services to their communities across the state. Next year's distribution will come at a critical juncture for legal services organizations. For the first time in 5 years, there will be no state appropriated funds for homelessness prevention legal services. At the same time, COVID-era grant programs are concluding, and significant sources of federal funding, such as Victims of Crime Act funds, are shrinking and disappearing. The need for legal assistance remains high, and legal aid organizations are depending on this funding to maintain their services. The IOLTA statute imparts a duty upon the State Bar and the Legal Services Trust Fund Commission to distribute IOLTA funding annually for the provision of civil legal services to indigent persons. By approving this recommendation, that duty will be met, and legal aid organizations can continue to do the incredible work that they do across the state. Again, we ask that you approve the Commission's recommendation of a $252 million IOLTA grant distribution for 2025. Thank you for your time.
All right, thank you.
Next, we have Lee Strauss.
All right, good morning, Mr. Strauss.
Can you hear me?
Yes.
Okay, great. All right, good morning, Ms. Wilson and members of the Board of Trustees. My name is Lee Strauss. I am a licensed member of the State Bar, and I'm currently serving as an assistant presiding arbitrator for the State Bar's mandatory fee arbitration program. In addition, I'm the deputy chair of the Los Angeles County Bar Association's Attorney-Client Mediation and Arbitration Services. I wanted to give you my perspective on agenda item 5.11, which is the request for approval of the mandatory fee arbitration filing fee increase. I believe the proposed filing fee increase may have an unintended negative impact, not only on access to the State Bar's MFA program, but potentially on the local bar association MFA programs throughout the state. The State Bar's MFA program is seen as providing model rules and guidelines for the administration of mandatory fee arbitrations. If the State Bar's MFA program institutes the fee structures that are being proposed, the potential knock-on effect is that the local bar association programs may be encouraged to also seek to increase their fee structures. If this result were to materialize, it would negate the basis for which the MFA Act was originally enacted as an alternative, low-cost, much more streamlined forum than the courts for resolving these types of disputes. While it is necessary to incur costs to administer these programs, instituting filing fees to cover 100% of the cost would be in direct contradiction to the purpose of the program if the fees would limit the public's access to the services. I am not opposed to the increase from 5% to 6% of the amount in dispute. What I strongly oppose is the proposed caps, which could see participants of this program having to pay upwards of $20,000 to have their dispute heard, whereas before the cap currently is $5,000 and currently the highest cap among the local bar associations is $7,500. This is a classic example of the tail wagging the dog. The administrators of the State Bar MFA program are reacting to the directive of the state auditor's 2023 recommendations to have this program cover its cost. As such, this proposed filing fee increase is being driven by the sole purpose of revenue generation instead of the actual purpose of the MFA Act, which may potentially deny the public's access to the program. The State Bar MFA program has primary jurisdiction in areas of the state that do not have a local bar program, and many of these areas have lower mean income households, which means that these large parts of the state may have the public unable to access the program due to the proposed higher cost of entry. If these unconscionable fee caps are allowed to be enacted, I believe it will be incredibly difficult to deny local bar association programs from enacting similar caps. The survey that staff sent to the local bar programs that when I raised these concerns in May, did not ask the burning question of whether they would be encouraged to seek implementation of similar fee caps. It's my opinion that the survey was defective. I strongly urge you not to approve this request. Send this back to the program to come up with fee caps that do not shock the conscience and are not in direct contradiction of the MFA Act's purpose and intent.
All right, thank you, Mr. Strauss. Next up.
Next, we have Maeve Elise Brown.
All right, good morning, Ms. Brown.
Good morning. Thank you so much for the opportunity to speak to you today. I am the Executive Director of Housing and Economic Rights Advocate, which is a nonprofit law office that provides free legal services statewide. We have a broad economic justice and anti-discrimination mission. Within that, we focus on household debt and credit concerns and more classic homelessness prevention strategies. I would like to speak to item 6.4 and also want to express my support for the recommendation of distribution of $252 million in IOLTA funds in 2025. My reason for speaking in support of this is because there's tremendous need out there that hasn't ended. People have not recovered yet. I will state the obvious. People have not recovered yet from the pandemic. The services are still greatly needed. Our program will lose about $1.4 million. That was funding that was COVID recovery related. I want to share that we have been trying very hard. We're lawyers. We can read. We see the contract. We knew the contract and the termination date on all of these contracts and have been trying hard to raise funds from other sources well before we got to this time period. There's very little funding out there in the foundation grant world or other pieces of the grant world for legal services, for direct services. So I can't begin to express the importance of the funding that comes through IOLTA. This level of funding would give more time to programs across the state to find other sources. It's also ironic that it's very hard to raise money for the money you need to replace while you still have money in hand, which is one of the quirks of the foundation grant world. And so it was really very difficult to raise replacement money far, far ahead of the anticipated end of the contract period. So the support is at IOLTA at this level is extra needed at this time. I also want to note it would be really tremendously wasteful, quite a loss to have to retrain attorneys down the line that we've spent these years training to do really great work. And we're hoping to hang on to these good people to continue to do the good work that the public really desperately needs. So I thank you for your attention and for your careful consideration of item 6.4.
All right, thank you for your comments. Next, please.
Next, we have Carmen McDonald.
All right, good morning, Ms. McDonald.
Good morning. Thank you so much for allowing me the opportunity to be here. I am the executive director for the Los Angeles Center for Law and Justice. We are a nonprofit law firm providing free legal services to survivors of domestic violence, sexual assault, and human trafficking. We've been providing legal services in Los Angeles for over 50 years. I'm also echoing the comments that Lauren and Maeve had made and asking that the board approve the decision of the commission to approve the 2025 IOLTA distribution in the amount of $252 million, agenda item 6.4. Our organization has already had a devastating loss of funding with the Victims of Crime Act that is money that's delivered through the California Office of Emergency Services. We lost $2 million over the next 5 years last year. The impact on our organization is that we have had to lay off staff and we have had to close intake to the most vulnerable survivors in our society. We are also going to be losing the Homelessness Prevention Fund from the State Bar, which is also upwards of $1 million. And we had cuts to our California Department of Social Services, Immigration Services funding. And just as Maeve was saying, these are some items we expected some cuts to. We also did have COVID funding cuts and $400,000 a year, but they all hit us in the fall and in January. So I'm also trying to fundraise and recover a loss of multiple millions of dollars over the next 5 years and to continue to deliver these critical legal services. I do ask that you then approve this recommendation. Thank you so much for the time to be here today.
All right, thank you for your comments. Are there any other members who wish to address this board?
Yes, we have Ray Hayden next.
All right, good morning again, Mr. Hayden.
There we go. All right, so I'm in support of the 6.2 session that's going to come up later on today, and that is for the approval of the Kaplan contract, which is not what I suggested back in June of 2023 when I spoke with California Bar. My suggestion was to create subgroups for each individual subject to be tested. They make their own multiple choice questions, have them vetted by the psychometrician in Cal Bar, and then set up. And there's still, actually right now, still plenty of time to do that. If that contract doesn't work, there's still plenty of time. I can do it in 3 months, so I know Cal Bar can do it in 4. The issue is that there's a potential for a 5-year contract, potentially. And if that was to happen, that's perfectly fine. Cal Bar is going to save millions of dollars, but they can save, by the suggestions that I was making, they can save many more millions of dollars if they had gone ahead with that other program that I was discussing that I will submit additional information to down the road. I don't want to interfere with the contract, but I'd like to see it happen at this point because the evolution of the bar exam to become a remote exam is a very important one. They did it during the pandemic. They can do it now. And Cal Bar can be the leader in getting it done. And it's about time for this mess of the bar exam everywhere to be fixed. And that's my point, is the remote aspect of it. I live in Florida, and during the pandemic, I was able to take 3 California bar exams remotely from Florida. Followed all the procedures and everything else, got the job done. The issue is going to be if they can do a remote, if Cal Bar can do the remote exam, if it's only going to be just in California testing centers, or if they take the wide view and everybody who's taking it can do it remotely, either in a testing center or at our home in a sterile room or whatever we have to do to get the job done. I'm sure people all around the world who actually sit for the California bar exam would greatly appreciate that. For us to go to California, if it was a half and half, half in person, whatever, anything like that, it's actually tremendously more expensive for us to travel to California for the single day, or especially even 2 days if it ends up being that deal, to sit for a locally remote exam. I hope that makes sense. I'll stay in contact with Cal Bar, and hopefully it will make sense. But I would like to see the contract happen, and I would love to see it be a broad-based remote opportunity for people to sit for the California bar exam in February 2025. Thank you very much and have a wonderful meeting.
All right, thank you, sir.
Next, we have Todd Hill.
All right, good morning, Mr. Hill.
Good morning. Esteemed members of the Board of Trustees, thank you for giving me the opportunity to speak today. My name is Todd Hill, and I come before you as a former student of People's College of Law, PCL, to share my experiences and concerns about the state of legal education. I've authored a document titled Degrees of Deception When Legal Education Fails, which I hope will shed light on critical issues that need your attention and action. The pursuit of a law degree is often seen as a noble endeavor, a path to justice, and a means to advocate for those in need. However, when the institutions responsible for educating future lawyers fall short of their obligations, the consequences can be deeply troubling and far-reaching. My experiences at PCL highlight several areas where improvements are urgently needed. The document I present outlines issues such as alleged deceptive practices, misrepresentation, and challenges in providing quality education. These problems are not isolated incidents, but reflect broader systemic issues that affect many students, particularly those from marginalized communities. High attrition rates and low bar passage rates among these groups underscore the need for a more supportive and equitable educational environment. The State Bar of California's policies and oversight play a crucial role in maintaining the integrity of legal education. I believe there are opportunities for the State Bar to enhance its support and protection for students, ensuring that all educational institutions meet high standards of transparency, accountability, and quality. Degrees of Deception is not just a recounting of difficulties. It is a call to action for constructive reforms that can restore trust and integrity within our legal education system. By addressing these issues, we can create a more just and equitable pathway for all aspiring attorneys. You all should have a copy of Degrees of Deception distributed to you as my written public comment. I urge you to review this document thoroughly and consider the implications of these challenges. Together, we can work towards meaningful changes that uphold the values of justice and equity in the profession. Thank you for your time and consideration.
Thank you, Mr. Hill. Next up.
Next, we have Maria Grujalva.
All right. Good morning, Ms. Grijalva.
Good morning. Thank you for this opportunity to speak. I want to speak very briefly about transparency and the importance of transparency. And so I tried to do a public records request for disciplinary records of Yolo County District Attorney Jeff Reisig, but I was unsuccessful. And then I came across a lawsuit from Justin Beck against the bar because they were trying to, or he's trying to get information regarding Kenneth Cantansardi, or, excuse me for butchering up the name. But I think part of the issue here is that the State Bar, being an administrative arm of the Supreme Court, has the impression that it's not a state agency. And that's what I'm wondering if it's the problem, because the bar is a state agency, and there's really no doubt about that. And being an administrative arm of the Supreme Court does not exempt your public responsibility for transparency. I actually tried to hire an attorney to do a public records request for me and ask for that exemption from you, Chair. And I had so much problems doing that. And so I ended up getting one of those programs, like a Legal Shield, kind of those programs. And I said, without giving them background information, I said, I need to do a public records request to a state agency regarding certain records. And they're like, oh, okay. And then when they ask for the specific, they go, oh, we can't actually do that. And I have this letter where they're explaining away how they have the discretion not to do what I paid them to do. And so they don't want to sign their name. They don't want to put their bar number next to that letter. And this reflects why we need transparency. And when you're not being transparent, what is it that you're hiding is what you want to ask yourself. And of course, most importantly, the public, because this is a public venue. And it's important that the public be informed. It's important that the Board of Trustees, everybody have the same information, and that way one person doesn't have more information than another person, and they're hoarding information. So anyway, thank you for this opportunity to speak, and please, transparency is critical, and that really is good. Thank you.
Thank you for your comments. Next, please.
Next, we have Benjamin.
All right, Benjamin, your microphone should be activated.
Radio sources. Can you hear me now?
Yes, we can.
Okay, good. I was wanting to speak also about the Kaplan contract, though I want to second the prior commenter on the Public Records Act exemptions being overly aggressively asserted and the chilling effect that can have on legal practitioners. With respect to the Kaplan contract, it seems that one of the chief issues with copyright materials that the NCBE has been asserting is the fact that these need to be considered MBE-like, or at least the language in the contract that leads them to believe that it will be entirely based on the copyrighted materials is seeming to derive from this requirement for 2-year notice to law schools and what staff felt they needed to do and when writing the terms of or the definition parameters of what they would need from Kaplan in order to not trigger that statute. I think the more productive solution would be to work with the legislature to amend that statute to give the flexibility that's needed to do the cost savings everyone wants and the remote testing flexibility everyone wants, rather than to try to parse a version of MBE questions that both simultaneously doesn't trigger that statute and at the same time doesn't give the NCBE room to argue a copyright violation, especially when they have the incentive to interpret their IP very broadly, given that they're the ones who lose if Kaplan is given this contract, because they're the ones who stand to give the contract if Kaplan is not able to proceed, and they really don't have that much incentive to give flexibility or anything like that here. I think you should focus your efforts on getting an exception or to this statute with regard to the amount of deviations that Kaplan would need to have to feel safe from a copyright infringement action by the NCBE, and work with the legislature on that. I'll point out that Assemblyman Berman's letter to you during the testing accommodations rules revision specifically advocated for the remote testing option and the ability to do the remote testing option equally with people with disabilities, which was something you'd claimed the NCBE had been interfering with. So there is legislative interest already expressed to you that could be tapped to do this amendment to the NCBE rule. To the 2-year rule. Thank you.
All right, thank you. Next, please.
We do not have any additional members of the public wishing to address the board.
All right, thank you. This concludes the public comment portion of the meeting. We'll go to item 1, which is the chair's report. The first part of my report involves a bittersweet presentation, and that is recognition of Steve Mazer. So, Mr. Mazer, if you are so inclined, would you mind coming up to the podium? All right. Mr. Mazer is retiring from his work here at the State Bar, and as a token of our appreciation, we have a resolution from the State Bar Board of Trustees, and I want to read a couple of the items and the whereases that are contained in this resolution, and I know even these pale in comparison to the amount of work and time you've invested in this organization. Whereas Stephen J. Mazur was hired by the State Bar of California as the Director of Operations in July 2008 and promoted to become the first Chief Administration Officer in September 2017, with responsibilities that included information technology, human resources, and general services. Whereas Steve Mazur has been a treasured member of the State Bar leadership team for the last 7 years and the senior executive team in the years prior. Whereas Steve has been instrumental in leading efforts across the bar that are too numerous to list. Just a few of his more recent professional accomplishments include professionalizing the bar's HR operations, deploying our HRIS and procurement management system, Oracle Fusion, leading, organizing, and completing the purchase of our Los Angeles building and its tenant improvements, earning a Silver Award by the LA Business Journal Real Estate Awards, as well as board presidential recognition, winning the 2016 and 2017 Northern California BOMA Toby Awards for government buildings, leading, organizing, and completing the sale and leaseback of the San Francisco building, developing and maintaining strong relationships with the bar's bargaining units, strengthening the morale of State Bar staff, taking quick and decisive action in response to the COVID-19 pandemic, and successfully transitioning the organization to a remote work environment, leading a return to a healthy workplace and wrangling the many day-to-day operational issues that are critical to the bar's operations. And the last resolve that I will read is resolved that the State Bar Board of Trustees and the leadership of the State Bar of California expressed their deepest appreciation to Stephen J. Mazur for his unparalleled work and invaluable contributions to the State Bar of California. And this is adopted by the State Bar of California on today's date, July 18, 2024. So, Mr. Mazur, before I give you this proclamation, do you wish to address the board?
I'll just say briefly, it has been a tremendous pleasure and privilege to work with all of you, to learn from you, and to be part of the important work of the State Bar, and I wish everyone all the best for the future. Thank you so much.
Steve, yes. And Steve, we absolutely would not be where we are at without your tireless efforts. So on behalf of the board, our sincere well wishes in your future, and I hope our paths cross again soon. All right, the second portion of my report involves a new appointee to the Board of Trustees. I'd like to welcome Cynthia Grande to the board, and just wanted to give you an idea of her background, and then I'll give her the opportunity to address the board if she wishes. Cynthia Grande is an attorney member of the State Bar of California, and she has been appointed by Assembly Speaker Robert Rivas in this year, 2024. Ms. Grande is the founder of the Grande Law Group. It's a law firm located in Los Angeles. Her practice focuses on bankruptcy, family-based immigration, and investor visas. Ms. Grande grew up in a predominantly Spanish-speaking neighborhood in San Pedro, California, and Ms. Grande witnessed firsthand the challenges many in her community face in accessing legal help due to language barriers and resource limitations. This experience inspired her to become an attorney and dedicated to serving underrepresented populations and improving access to justice. Ms. Grande is committed to shifting the public perception of working with lawyers with the goal of helping her clients navigate legal issues with comfort and confidence. She often represents clients who are unfamiliar with the legal process and strives to provide them with an exceptional level of service and support. Ms. Grande received her Juris Doctor from the University of Pacific McGeorge School of Law and her undergraduate degree from the University of Southern California. So welcome to the board, and if you wish, please feel free to share some comments.
Oh, there we go. First time. Hello, everyone. Thank you so much for, I'm so excited to be here. the work that I do with my clients over the past almost 15 years of being an attorney has been the immigration and bankruptcy law. Unfortunately, there are a lot of reasons why the state bar has to get involved, and I'm really looking forward to share my perspective and of my clients and to be a contribution on this board. Thank you.
All right, welcome, and we look forward to having your unique skill set put to work here at the State Bar. So we will be addressing appointments to various committees probably at the next meeting in September, and so look forward to plugging you in to the work here on the various committees. I have some remarks to close out my chair report. I recognize that it has been a lengthy chair's report so far, so just beg your indulgence once more. I was thinking this morning about various races that I've run, and if you've ever competed in a race, whether it's running, biking, or triathlon, you know that hard work in the buildup shows forth on race day of the event. And if you put in that work, your chances of success improve. They're not necessarily guaranteed, but they absolutely do improve. As you might ask yourself why I'm talking about competing in a race, and really it correlates to the State Bar, to us asking for the largest fee increase in recent history. As has been talked about in our legislative priority meetings, has been talked about in my chair reports, it's no secret that we as a State Bar need additional funding. And to that end, staff and the board have had numerous meetings with stakeholders, legislators, and legislative staff. And through these meetings, we've been able to talk about the hard work of this board, the hard work of staff, all of which to improve our governance, improve the profession, and to improve the public's perception of the bar and the legal profession. I had the pleasure of testifying in front of the Assembly Judiciary Committee in April, and recently I testified in front of the Senate Judiciary Committee in support of this year's fee bill. As will be discussed in the legislative priorities section of our meeting, the current bill goes a long way to meet our needs, and we're working with the legislators to work out final details to shore up other vital aspects of our infrastructure. In our meeting over the next several days, we'll have the opportunity to consider the implementation of recommendations of the ad hoc committee on the discipline system. And just by way of just some history, given that we have a couple of new board members, this ad hoc committee was born out of the work of the bar in conducting the first of its kind review of the discipline system and whether there was a disproportionate impact on minority practitioners. This report was delivered to the board in November of 2019, and since then, there's been a furious and monumental amount of work that has been conducted to address those issues. First up, we had Professor Robertson make recommendations to the board. In early 2020, the board was able to implement several reforms, and then to continue the work of the recommendations of Professor Robertson, we formed the ad hoc commission in April of 2021, which submitted proposals to the board in early 2023. This board directed staff to explore these reforms, and today is perhaps the culmination of many of these discussions and their implementation. And we do have two members of our board who served on the ad hoc commission, well, myself, Trustee Good, and then Trustee Buenaventura, and so look forward to our discussion. But all this to say that the path we've taken as an organization and the necessary reforms that we have undertaken provide the opportunity to show the legislature that we are wise stewards of the money entrusted to us, and that it's important to continue to invest in reforms that are near and dear to the hearts of Californians and near and dear to the priorities of our stakeholders. We take on these difficult topics, and in order for us to continue our work, we require that additional funding through the increase in fees. I thank the legislature for continuing to monitor and direct our progress, and I look forward to continuing to work towards a fee bill that meets our very real needs. That concludes my chair's report. And I'll turn over to Leah Wilson for her Executive Director's report.
I don't have one. I'm going to make my remarks with the various items. Thank you.
All right, thank you. We'll turn next to item 3, which is our open session minutes. And I would note that we are using a new system to track our agenda items, and hopefully all trustees receive training on how to access those items. If you need some additional time to pull up items, please let me know, and we'll take that a little bit, we'll take that as it comes up. So, but thank you to staff for continuing to work to improve the way that we allow the public to access these posted agenda items. With that said, item 3 is our open session minutes. 3.1 is the approval of May 16, 2024 Board of Trustees open session minutes. And I would just ask if there's any member of this body who believes any modifications need to be made. And if I have no hands raised, may I have a motion and a second? Okay, I'm not sure. I heard a couple things. Okay, first by Trustee Sewell. Is there a second?
Second.
Okay, I think that was Trustee Buenaventura, and I'm sorry, there's some background noise on one of the attendees. If you could mute your line, please. Okay, so first by Trustee Sewell and second by Trustee Buenaventura. May I have a roll call vote, please?
Barahona?
Aye.
Buenaventura?
Aye.
Chen?
Aye.
Narrows?
Aye.
Good?
Aye.
Grande?
Abstain.
Huser? Shelby?
Aye.
Stevens?
Aye.
Soel?
Aye.
Tony?
Aye.
Trejo, not present. Stallings?
Aye.
12 ayes, 0 nays. Minutes are adopted.
All right, thank you so much. Just to give the board a broad outline of the way the meeting is going to go, we're going to go next into item 5, which is our Board of Trustees sitting as the Regulation and Discipline Committee. We will then go to our consent calendar, which is number 4. And then after that, we'll go into closed session for our regular board meeting, and then continue on through our business after that closed session meeting. Thank you for everybody's flexibility in that, and just wanted to try and accommodate schedules as best possible. So item 5, we will now move into the Regulation and Discipline Committee. Item 5.1, these are the proposed amendments to Rules 9.8 and 9.31 of the Rules of Court, and proposed new Rule 9.33 relating to expungement of attorney discipline and administrative actions. This is a request to circulate for public comment. And before we get into that agenda item, this is definitely a rules-heavy agenda, and just remember that all of these rules do serve very important functions here at the State Bar, and go to improving our ability to administer justice in a fair and equitable manner. So we thank you for your attention to all that. And here to present, we have Deputy Special Counsel Mia Ellis, and looks like Steve Moawad. Great to see you.
And before you two get started, I do want to put something up. This is in reference to my comments about making remarks during the items. And this really ties nicely, Chair Stallings, to your overview of the ad hoc commission. I wanted to just give the board a little sense of what you've done vis-a-vis the ad hoc commission recommendations and where we are going. So you can see on the screen here all of the various recommendations that the board has actually directed action be taken regarding, and where we are with them. So you've completed the modification of the ENEC process, including providing an option for a pre-conviction transmittal conference. Today, and this is the item you're about to hear now, you are dealing with expungement and website removal, discipline, and administrative suspensions. This is the second time you will have heard at least the expungement of disciplinary records aspect of this item. Today, also, you are going to receive the proposal to modify the model by which discipline costs are assessed, and we are asking you to approve the issuance for public comment of a modification around monetary sanctions. Also today, you're asked to approve the modifications to the progressive discipline standards. This item is coming back from public comment for you to approve today. So at the end of today, we will be more than halfway done here. And then you can see two other items slated to come before you this year. Clarification, updated rules around referrals to the alternative discipline program. And just for the benefit of our new board member, if you don't know, that is the program that lawyers with substance abuse or mental health issues are eligible for if they are sort of under the jurisdiction of State Bar Court. Also this year, we're going to bring to you a proposal to governing removal of criminal conviction transmittal history from the website in certain circumstances. And this is specifically where an attorney's criminal conviction, the underlying basis for that conviction is something that has been expunged pursuant to 1203.4. So that's kind of the last item on our website removal list. And then unclear court-appointed counsel pilot program. This is kind of the heart, in a way, of the ad hoc commission recommendations, looking for the board to allocate funding to support an appointed counsel program for respondents in the attorney discipline system. We said we were going to hold off on this pending the outcome of our fee bill discussions. At this point, we're not quite there yet, and I think the board will have to decide once that fee bill is passed if you do want to allocate some funding to support the court-appointed counsel pilot program. So that's all of it, and again, after today, we'll be halfway done. So I just wanted to provide that bit of context and then turn it over to Mia and Steve. Go ahead. Yeah.
Oh, Trustee Tony.
I'm sorry. So on this item, when I tried to open it in the new system, I get 5.1. That's the place, right? We're on 5.1. And it just has the sentence about proposed amendments, but then there are no proposed amendments.
Did you go down to the attachment? There's attachment A.
No, I couldn't find any attachments.
Go back to the agenda.
You said to ask questions if we can't
Okay.
figure out this.
Oh, I'm sorry.
I'll
I think you're
try.
looking at the first page, and if you go down to the second page, that's where the agenda
I
item
didn't see a
is.
second page, okay.
All right, no worries. Okay, take us away, please.
Thank you. Good morning, trustees.
Oh,
We do
could
have
you pull the microphone a little bit closer?
do that. Is that better?
A little bit.
How's that?
Perfect. Thank you.
Okay, again, good morning, trustees. In May, the board directed staff to draft a proposal, rule of court, regarding expungement and non-disbarment discipline after 8 years. This item before you proposes a new rule of court 9.33 related to expungement and request a 60-day public comment period. The proposal also has a staff recommendation for proposing a new state bar policy on removal of non-disbarment discipline and administrative suspensions from licensees' public profile, which would also, we would also like to circulate for public comment. I'm going to briefly go through some of the information on the slides and also in your staff report. Again, expungement is removal of information from a licensee's public profile page of the record of discipline. Expungement would apply to active, voluntary inactive, and resigned attorneys. Resigned attorneys would cover those who resign with or without charges pending. Also, as discussed at the May Board of Trustees meeting, discipline can be used as an aggravating factor and as a prior record of discipline. Eligibility for expungement, it would be a one-time relief, and it would be for licensees with one prior discipline. Licensees who have disciplinary matters pending before the State Bar or Supreme Court would have to wait until those matters are resolved, closed, or dismissed. Again, at least 8 years would have passed for the eligibility for expungement. For private or public approvals, it's past 8 years past the effective date, or for state suspension termination after the term of probation. And then for actual suspension, we indicated that it's termination of probation or reinstatement following termination of the actual suspension, whichever is later. This issue was addressed at the board meeting last time, and based on discussion from the board, we opted to include both, but whichever is later. Next, with respect to the State Bar policy regarding removal of non-disbarment public discipline and administrative suspensions from the licensee's attorney profile page, the criteria for removing non-disbarment public discipline would be the same as expungement. It would also include administrative suspensions. So it would be automatic removal of the first two administrative suspensions following the end of the suspension period. And then the next administrative suspensions that are pending, the licensee would have to wait 4 years to the end date of each respective administrative suspension period. Again, we're requesting to circulate this draft Rule of Court 9.33 for a 60-day public comment period, and the staff will also circulate for a 60-day public comment period the State Bar policy on website removal. Happy to take any questions.
All right, thank you. Any questions? All right, Trustee Buenaventura, and then we'll go Trustee Good.
Yes, thank you, Mr. Chair. If I could ask the staff, when it comes to, so when someone, what I understand, it's going to be after the termination of probation, that's when the time served starts tolling. What is the typical probationary period that happens?
It could depend on the state suspension or actual suspension. Sometimes probation ranges from 1 to 3 years.
Okay, so my understanding is if they're once they've been disciplined, maybe perhaps the longest they're on probation for is 3 years, and so then you would add on the 8 years, so that would basically mean 11 years until someone could apply for expungement. Am I correct?
If that is the term of probation, yes. Or if there's a possibility, if it could be longer, depending on if they were subject to a higher level of discipline and subject to a reinstatement petition.
Got it. All right. Thank you, Mr. Chair.
All right, thank you. Trustee Good.
Yeah, thanks so much for the presentation. I had a question in the accompanying written materials. It indicated that 3,680 licensees may be able to avail themselves of expungement if this rule is adopted by the California Supreme Court. And I had a question about, was that current active licensees? And then two, if it is, how many of those then would have no discipline posted at all? Or, you know, are some of those folks people who have had multiple instances and so they're just getting one expunged? Just had a question about that. Thanks.
I believe that the number of people who would be impacted includes all licensees, including some who are deceased. And to answer your question, because of the criteria that only people with one prior discipline are eligible, it only includes people with that one discipline. So yes, the people who would be eligible for the discipline would have nothing on their discipline history, if that makes sense.
And there, I think in editing down the item, I removed the distinction between active and inactive. We do have that data. I don't know if you guys have it handy, but yeah.
I do. It's active attorneys, it's 1,740, and then inactive attorneys, it's 587. Resigned without charges pending, 99, and deceased, there's 1,254. For a total of 3,680.
And because of a late change to the rule, that number may actually increase when we include resigned with charges pending. But again, that would only be people with one prior discipline, so.
Okay, so I'm sorry, what's the total if we exclude deceased people?
Less than 1,254.
It's the total minus 1,254, so.
So like 2,400.
Okay.
Yep.
All right, and I think that's just more fair for us to be talking about, right? I thought, in any event, I mean, providing relief to deceased people just, in any event, I think that's what we should be focused on rather than the 3,680 is a bit illusory. So thank you.
I will just say we do get requests for by family members of deceased people. So I agree with you. It's a different implication, but certainly we do get those requests. People feel very strongly about having that on the records of some of their family members and loved ones and colleagues.
All right, thank you. Trustee Tony.
I think this is a strong proposal because we spent several meetings discussing it. A lot of edits and amendments and changes have gone into it. I have just a factual question. So number 3 in definitions talks about the discipline, what the definition of discipline is, and that seems pretty clear. I would like to know the difference between that and administrative suspensions, because I'm not against it being treated a little differently. I'm guessing it's a lesser than the discipline, but I don't know what an administrative suspension is.
That's actually a great question, and it's not an obvious answer, but for rules of the state bar, where an attorney doesn't comply with certain requirements, they are generally moved to inactive or suspended. There's 2 different categories. For non-payment, for example, it's a suspension, but it's an administrative suspension. It's not a disciplinary suspension. We also have, for example, for CTAP and other requirements, they are inactively enrolled, and that is also an administrative inactive enrollment. So it's those 2 non-disciplinary types of actions that would be dealt with through the website removal of the policy.
Thank you for the clear explanation, and it makes sense to me.
All right, anybody else with questions or comments? All right, Madam Secretary, could we have the resolution put up on the screen? All right, so again, this is to put these rules out for public comment for a period of 60 days.
I'll move the item.
Thank you.
I'll second.
All right, first by trustee Tony, second by vice chair Cisneros. Madam Secretary, can we have a roll call vote, please?
Barahona,
Aye.
Buenaventura,
Aye.
Chen,
Aye.
Cisneros,
Aye.
Good,
Aye.
Grande,
Aye.
Huser, Shelby,
Aye.
Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo, not present, Stallings.
Aye.
12 ayes, 0 nays, motion carries.
All right. Thank you, Ms. Ellis and Mr. Moawad, for your presentation. Moving on to item 5.2, this is Ad hoc Commission on the Discipline System, adoption of new discipline cost model, and request to circulate monetary sanctions rules for public comment. And this item is being presented by Executive Director Leah Wilson, and then Attorney Suzanne Grant, Shelby King, and then Principal Financial Analyst Jake Lewis. So if we could promote remote attendees.
I will kick this off before I turn things over to Shelby. So as I mentioned earlier, today you are taking up another set of recommendations stemming from the Ad hoc Commission. They're two kind of discrete topics that we put together in one agenda item because they both deal with costs that are assessed to attorneys who are subject to discipline. So Shelby is first going to go over our proposal for modification of the rules governing the imposition of sanctions. And essentially, the proposal is to reduce the maximum exposure on sanctions. Louisa shares it.
I'm going to share.
Okay. And then I'm going to turn things over to Jake Lewis, who's going to provide the board with an overview of our recommended revisions to the model by which discipline costs are assessed. So these are charges that attorneys are levied when they participate in the discipline system for the costs of OCTC and State Bar Court personnel. So two kind of discrete items that we put together in one agenda item. So first I'll turn things over to Shelby. Shelby, move your microphone closer.
Got it. Can you hear me now? Okay.
If you could just pull it just a little bit closer.
Yes.
Sorry about that. Thanks.
Oh, sorry. At the September 2023 board meeting, staff reported on the Ad hoc Commission's recommendation to eliminate monetary sanctions. Monetary sanctions are outlined in Business and Professions Code, Section 6086.13, and State Bar Rule 5.137 provides guidelines for its imposition. While a statutory amendment would be required to completely eliminate sanctions, amendments to Rule 5.137 could reduce or eliminate State Bar Court's recommendations for sanctions in many cases. At the September meeting, staff recommended drafting two amended versions of Rule 5.137. One version would remove State Bar Court's authority to recommend sanctions in non-disbarment cases, including suspension and resignation with charges pending. Alternatively, the other version would retain State Bar Court's authority to deviate from the $0 recommendation up to the statutory maximum in non-disbarment cases. Upon further consideration, staff determined that State Bar Court should retain their discretion to recommend sanctions in non-disbarment cases. Thus, this item recommends moving forward with one amended version of Rule 5.137. This version of the rule, included as Attachment A, contains two substantive amendments. First, the recommended sanctions amount for disbarment orders was reduced from $5,000 to $1,000. Additionally, sanctions are not recommended in cases of suspension and disbarment or resignation with charges pending. Second, a subsection was added to the rule to clarify that installment payments for monetary sanctions will be added to the attorney's annual fees. This mirrors the authority in Rule 5.129F, which similarly allows State Bar to add installment payments to discipline costs for attorneys to the attorney's annual fees. This is necessary for the collection of monetary sanctions. So this item requests board authority to make the amended version of Rule 5.137 available for public comment for 45 days. After the rule is adopted by the board, it will need to be submitted to the Supreme Court for approval.
All right. Jake, discipline costs.
Okay, thank you, Shelby, and good morning, trustees. My name is Jake Lewis, and I'm pleased to share with you the updated discipline cost model today. So as we know, Business and Professions Code directs the State Bar to recover the cost of disciplining attorneys. Currently, our discipline costs are based on a model developed in 2010, adjusted annually using a formula that uses both Employment Cost Index and Consumer Price Index data. The Ad hoc Commission on the Discipline System reviewed the State Bar's discipline cost model and found its costs to be higher than those of the very few other licensing agencies that assess fees for adjudication, and that its practice of assessing fees for trial and review proceedings is unusual, in that it appears to penalize attorneys for choosing to appeal their cases. In September 2023, the board supported that staff assess the possibility of updating the current discipline cost model from 2010 to scale back discipline costs, including but not limited to trial and review, as well as so that it is predicated on current operational processes rather than simply modifying the existing model. Board commentary also supported that staff assess and revise State Bar Court rules of procedure so that discipline costs may be waived at the court's discretion, while retaining the court's ability to impose full costs for trial and review in appropriate circumstances. We've confirmed that no revision is necessary, as the State Bar Court already has the discretion to do so, so that's why we're here today. If we go to the next slide, we can see the current discipline cost model calculates discipline costs by case type and settlement stage. Costs are calculated for each case type and settlement stage as the sum of three elements. 1, the number of times the task is performed, 2, the average time it takes to perform the task, and 3, the hourly rate of staff that performs the task. Important to note is that the data that forms these three elements comes from a time study from 2010, which means that the rates of staff, tasks, and time it takes to perform said tasks are outdated. However, as I mentioned before, discipline costs have been adjusted annually by a CPI. Enhancement charges are also assessed in the current model for cases comprised of multiple investigations, and a resignation fee is also in the current model as well. If we move to the next slide, we can see the current cost is updated by that CPI. Or we're going to actually move into the new model, sorry. So
This
we might have
is probably
skipped
not
one.
in the right order. Maybe if you can go forward one more. This is the current cost, yeah.
Okay, we can see the current cost is updated by that CPI. As you can see, the discipline costs increased sharply from one day to a multi-day trial and review by more than $10,000. So in line with the board direction, our main goal in updating the discipline cost model was to address the need to update the model to reflect current operational practices and scale back discipline costs. Due to the lengthy time studies necessary to update the same discipline cost model with current procedures and the lack of data available from the original 2010 model, a new methodology similar to maintain in the long run has been developed to calculate the assessment of discipline costs. So we can go to the next slide.
Back one, thanks, Shelby.
Okay. So as for how it works, the updated methodology moves away from an approach tied to the amount of staff time spent on tasks and stages, again, primarily because current time data is not available and would be resource intensive to generate on either one-time or ongoing basis. Instead, the new methodology derives costs from budgeted expenditures. So there are 3 data sources used in the new model, and you can follow this in Table 3 of the agenda item if you'd like. 1 being the total OCTC and State Bar Court prior year actual budget minus the cost of attorney and judicial positions, as the governing statute for discipline cost calculation does not allow for attorney costs to be assessed as a part of discipline fees. 2 being the percent of total cases closed with discipline out of all cases filed, and 3 being total number of attorneys disciplined. Using those sources, the model calculates discipline costs by multiplying the actual budget by the percentages of total cases closed with discipline out of cases filed per stage to determine a cost per stage. The model divides the total cost per stage by the number of attorneys associated with the cases closed in that stage to determine a per attorney cost by stage. There's also a per investigation cost enhancement for instances where more than one OCTC matter is reflected in a single State Bar Court case. This is calculated by multiplying the budget by total percent of cases closed with discipline out of all cases filed. Default and stage 1 costs are discrete in the methodology, which means a respondent is assessed cost only for that particular stage, whereas costs for stages 2 through 6 are stacked, meaning that an attorney is charged for each stage that their matter passes through. For example, an attorney whose matter closes after 1-day trial would be assessed fees for stages 1 through 4. So I think we might move to the next slide now. Yes. So we can see that some key points to highlight about the new model is that it simplifies the original model by reducing case types and stages. You can see this in the breakdown of this in your agenda item tables 1 and 2. This allows for State Bar Court to readily exercise its discretion to waive all costs associated with trial and review, unless, for example, a respondent is found to have pursued trial in bad faith. It also assesses costs from actual expenditures, so attorneys are considered to be paying for the direct portion of the budget they're responsible for, and it makes it more efficient to update, as time studies are long and costly. It also includes a multiple investigations enhancement, which allows State Bar Court to increase the portion of the budget an attorney is responsible for should they have multiple cases, and it removes a resignation fee as staff found this to be redundant. We can move to the next slide. One more. Okay. So the combination of an overall reduction in the amount of total costs that can be assessed, as you can see in this table, an increased ability for the State Bar Court to exercise its discretion to waive trial and/or review costs, advances the spirit of the Commission's recommendations while addressing concerns raised about their wholesale adoption. So as you can see here, attorneys are still able to be assessed discipline costs for multi-day trial and review proceedings. However, the costs are much lower and State Bar Court will have the discretion to waive these costs. We can move to the next slide, please. As for the fiscal impact, the new methodology will reduce the amount of discipline costs levied annually. So if applied in 2023, for example, assessed discipline costs would have been reduced from $2.5 million to $1.7 million using the new methodology. This is about an $800,000 difference. However, the State Bar does not collect most discipline fees assessed. So from 2019 to 2023, $4.8 million in discipline sanctions and costs were assessed, of which the State Bar has only received 10% in payments to date, or about $125,000 per year. So we can move to the next slide with that. And with that in mind, staff recommends that the board approve the new model for implementation as soon as possible, which depends on IT resources, but could be as soon as 2024 using 2023 data. Staff would also like to recommend an annual review of the discipline costs under the new model, as the new methodology relies on 2 variable factors: the number of cases closed with discipline each year and the number of attorneys associated with those cases. So given the potential variability of these factors in any given year, staff may propose modifications to the straight application of the model to smooth the impact of unusual or outlier data. That concludes my presentation on the discipline cost model work. Staff would be very interested in knowing how the board agrees with this proposal. Thank you.
All right. Thank you for that exhaustive review of all the hard work that staff has conducted in this. So I'm going to turn it over to the Board of Trustees. Are there any comments or questions?
I want to just raise one thing on the discipline costs. Right now, the maximum exposure is about $26,000. And under the new model, I believe it's something like $12,000. So it significantly reduces that maximum exposure. However, even at $12,000, we will be an outlier when compared to other attorney licensing entities that do impose any discipline costs at all. The highest we found is about $3,000. And although it was a little difficult to see, for example, the medical board's cost, it looked, and Jake, you could correct me, the average cost there is maybe more like $5,000 or something like that. So we'll certainly, even at $12,000, be higher than our peers, and it is a significant reduction. So included in your agenda item is an alternative approach where the board would establish a cap. And I believe that's at roughly $8,000 after the one-day trial stage. Is that it?
It's at stage 3 after pretrial, which would be $7,367.
So that's an option for the board to consider, is setting a cap. Even that cap, again, is higher than our comparable entities, but it's lower yet again than 12,000.
All right. Yes, Trustee Tony.
I appreciate the rationale of alignment, aligning the discipline costs of what's charged to attorneys in the discipline system with the cost of running it. That makes a lot of sense. And that's what I see the proposal in front of us doing, is updating from a formula adopted in 2010, and that's completely appropriate. So that makes a lot of sense to me. I do have a question that won't be resolved by this resolution, but that I would like the staff to consider. And that is, the problem of any regulatory agency is mandates with no enforcement, with no enforceability. The fact that the records that we were presented today show that of the fees assessed, 10% were paid and 90% were not paid. So it's kind of like, to me, that makes the issue of how much is going to be charged almost moot. And I would like in the future for the staff to think a little bit more about what are the ways that maybe there are other agencies that have these type of things. Do they collect? How do they collect? Because there's no point to having a fee and not collecting it. It's kind of like the same. And if there are no consequences for people who don't pay, then, because that's what it looks like, just from the outside, then it's kind of like, why should anybody pay? And so I know that won't be resolved. That's not part of this issue, this proposal, which I do support. But I'd like that to be a consideration, that maybe the staff comes back in the next meeting or two and say, here's what we found out. And it's probably an administrative thing. I don't even think you need to have board approval for what you end up doing. That's administrative, but I'd be interested. Thank you.
I will say that, in all transparency, we have had very lackluster collections efforts, at least since I've been at the bar. It's only quite recently that we've invested adequate time and energy in the collection space. So that's one. Two, our costs are quite high, and the longest repayment period I've seen that we offer is 3 years. So if you owe $30,000 or $50,000 and we're giving you a 3-year term to repay that, that's not quite reasonable for many people. So there are ways that we have this whole collections program structured that do not incentivize or support people in being compliant, even if they want to. So part of it is assessing a reasonable amount owed in the first instance that's not insurmountable, and then making it easy to repay. And us doing our work and really doing all the collections activity that's required.
All right, great question, and I appreciate the response. Any other questions for staff? Yes, Trustee Sowell.
I think this is probably a 3-parter. The change in the fee structure to me, and the cost structure to me, as Mr. Tony just indicated, makes eminent sense. My first question, though, is the goal to recover the cost of the actual discipline system? So are we attempting to try to set up a fee structure that would fully sort of cover the cost of the discipline?
It's not that it would recover the entire cost. It's just that it's trying to show, because, I think out of 17,000 cases that were investigated by OCTC in 2023, there was a very small portion, I want to say maybe 1,000 or 2,000, that were actually disciplined. So we're not trying to recover the cost of the entire 17,000, just the portion that's disciplined. So this works in a way where the attorney that is disciplined is paying for their portion of discipline, but not the entire, if that answers your question.
It does. Second question is another point that Mr. Tony made, which was that there's no consequences to not paying. Is that true?
Well, there are consequences in that we pursue judgments in superior court. So if you sell your house, we have a lien on your house. We engage in our contract with the Franchise Tax Board for tax intercept and COD. So there's that consequence. If you are subject to discipline and you owe fees or costs and you don't repay them, even when, say, your suspension is over, you are not going to be reinstated if you're not sort of in good standing with repayment of your fees and costs. So there are some, but the Superior Court judgment piece, Franchise Tax Board collection activity, that's relatively recent and not always been totally consistent. So that's our work and our responsibility. So there are consequences to the extent that any kind of collections activity is a consequence. I do want to clarify one other thing, though, in response to your question about full cost recovery. By statute, we are not able to assess any costs associated with attorney personnel. It's very interesting. So de facto, you're not covering the entirety of your costs, even for those cases that are disciplined.
And that's, did you say statutorily? That's
Yes.
Wow, okay. Third question is this item related to the offer and compromise collection item? So that there would be a structure that potentially would be set up that might entice folks to begin to pay? Is that this all linked together?
I think so. You know, the way I try to look at it is the offer and compromise program is looking backwards, and it's giving folks an opportunity to settle debt and debt levels that may have been quite high because they were imposed under this old paradigm. And it also, an offer and compromise program would have the benefit of bringing in some one-time revenue to the state bar. Prospectively looking ahead, you have a restructuring of the way fees and sanctions are assessed in the first instance, so they'll be more reasonable. So the idea is going forward, in conjunction with enhanced collections activity on our part, these lower fees that are more reasonable, and we're really doing our collections work, we will sort of right-size the situation going forward. And then the offer and compromise is allowing us to fix something that was done in the past. That's the way I view those two together.
Okay. Final question is just to go back to something that you said about the statutory prohibition about charging for the attorney's time. What might be the underlying principle as to why that was placed in statute?
I don't know. It doesn't exist only for us. It's also the DCA boards. I don't know, Jake or Shelby, I know maybe it was Suzanne that looked into that. So I'm not aware of the ledge history on that, and I don't know. So I'm sure it's something we can look into.
Okay, thank you.
Yes, Trustee Grande.
So I also echo the previous comments that I think this is definitely moving in the right direction. I think there's just a concern that it might be in the implementation, because with this structure, I don't think it's an intentional thing, but it could create a subconscious incentive to, because if costs are collected when someone's disciplined, right, and then not if it stays at the other stages, I would just be interested to see, once implemented, is there any kind of bias that shows up? So I don't know if there's a way to track that, but it's just a concern that something to consider once it's implemented if we do decide to proceed.
Yes, thank you for that. Looking to the trustees attending remotely, any questions, comments? All right. Louisa, can I have you put up the resolution on the board, please? All right, so again, this is a request to circulate for public comment. Well, it's an adoption of the new discipline cost model and a request to circulate for public comment. After you've had a chance to review the resolution, may I have a motion?
So moved.
All right, I think that was Trustee Chin first. Can I have a second?
Second.
All right, and I'm going to go, tie goes to the trustee in the room, Trustee Grande, with the second on that, sorry. And Madam Secretary, can I have a roll call vote, please?
Barahona?
Aye.
Buenaventura?
Aye.
Chen?
Aye.
Cisneros?
Aye.
Good?
Aye.
Grande?
Aye.
Huser? Shelby?
Aye.
Stevens?
Aye.
Soel?
Aye.
Tony?
Aye.
Trejo, not present. Stallings?
Aye.
It's 12 ayes, 0 nays, motion carries.
Chair,
All right.
may I ask a quick
Yes.
question? Could I request a 5-minute break?
Absolutely.
Thank you.
All right, we'll take a brief break, try and keep it about 5 minutes, and we will return back to our regularly scheduled meeting. So about 10:50. All right, welcome back from our brief break. We're going to go to item 5.3. Before that, I want to give some further direction here to the board. We should hopefully finish with RAD close to noon. We're then going to go to the consent calendar, and then hopefully that, again, we should get through that about noon. We'll then go into closed. At that point, we'll take a brief recess to grab some lunch, and then plan on working through lunch. I think we can get through a majority of these items today, so I want to try and keep that clip going. So anyway, welcome back. Item 5.3 is our report on the random audit of the Office of Chief Trial Counsel files closed between September 1st, 2022 and February 28, 2023, and then the Office of Chief Trial Counsel's response. This is being presented by our Chief Trial Counsel, George Cardona. So welcome.
Thank you. So this is one of our regular reports on the random audit, and hopefully that's up. So just a quick reminder, we have a random audit done of our closed cases, that is cases that are closed, not proceeding to discipline, over a 6-month period. Those are reviewed by independent outside auditors who are retained and overseen by MAD, the Mission Accountability and Advancement Division, not by us. The auditors look at both procedural and substantive issues and give us a report on that. They use procedures that were updated after recommendations from the state auditor in April of 2022, post-Girardi, and also now include a review of certain files that involve people who have 15 or more complaints or 40 or more complaints. We also updated our checklist for efficiency and effectiveness. That was done over that same time period. This is one of our last catch-up audits. We are still trying to catch up for delays caused by COVID-19. We are almost back on schedule. We will have one more catch-up audit, and then we will be back to more current. One of the things that's been unusual about the catch-up audits is that we're looking at cases that actually were closed prior to many improvements that we have already made in response to earlier audits. Once we get past the catch-up audits, hopefully we'll be more current, and the audits will reflect more our current procedures as opposed to our past procedures. So with that as background, this is what they looked at. They look at cases at each of the stages that we operate at: intake, investigation, and charging. They did those numbers of cases for that, and then they have a special set where they look at respondents who have 15 or more prior complaints. That's a new piece of the audit. In total, they looked at 255 closed cases. One of the things they do is look at cases to see if they believe that any of our closures were inappropriate, and they recommend reopening. This can be for a variety of reasons. This audit, they recommended reopening of 8 cases out of 255. This is one of the quality measures in our dashboard. You can see 8 out of 255, that's 3.1%. Our target is to keep that below 4.3%. We've been fluctuating around that target, and here you can see we're back down below that again. A couple of the things that they made recommendations on, one was our conflict checks. This was a new policy put in place in June of 2022. We revised that in 2023. We now give annual training on that. We just had our recent annual training in March. In response to one of their recommendations, we are going to modify our policy to provide clarity on whether a new conflict check is required when we issue a stay closed letter. So right now, we require a conflict check both at the time of assignment and before making a decision to close a case. Often after we close a case, we will receive additional materials from the complainant. That can stretch out over time. Sometimes we're receiving additional materials 6 months to a year later. We will likely be requiring that if it's after a certain amount of time past the original closure, the conflict check be redone to ensure that at the time the stay closed decision is made, there is no conflict at that point in time either. Another comment was on closing letters to complainants. One of the issues was they found a number of instances in which we had not included language advising the complainants of their right to seek review of that closure from crew. We did training on that back in February of 2023. Another issue was whether we clearly and concisely address all of the allegations and communicate clearly why we are closing those. One of the things we did in January of 2024 was put in place new form language for people to use to try and address that. This has been an issue in virtually every audit I've seen. It's an area where we're continuing to try to improve. We likely will be continuing to report back on what we do in this area. Another area was investigation delays. This has also been a topic in a number of prior audits. As you know, we underwent a reorganization in July of 2023. In January of this year, we adopted expedited investigation procedures, which had proven successful in the past for a limited subset of cases. We now apply those to virtually all of our investigations. And this too is an area where we're monitoring and watching. You'll see on our quarterly dashboard, this is one of the areas, the speed of our investigations, that we will continue to monitor and look at, because we need to try and increase that speed to the extent we can with our staffing. Another area was communications with respondents and respondents' counsel. One of this was more thoroughness and accuracy in our advice of the allegations. We have been working on that as well. The second was, as you know, as part of the reforms in response to the FARCUS study in 2019, we adopted a policy of sending respondents a notice, a one-page notice that advises them of the serious risks of discipline, and reminds them that they can retain counsel and that that might be of use to them in defending against it. We now send that as part of all of our inquiry letters. There was a notice in this random audit that in some cases we handle, we don't send inquiry letters. So some cases we get and we initiate at the charging stage, probation revocations, 9.20 violations, and some other cases. In response to that, we're going to be modifying our procedures to now include this one-page notice with the first letter that we send to a respondent in those types of cases as well, so that we will now cover all of those types of cases with this notice. Second, another thing was prior complaint histories. As you know, we have now adopted a number of policies to ensure that when we're making decisions in connection with various cases, we are looking at attorneys' prior histories of complaints and discipline. We've now modified our procedures, our investigation procedures that we put in place of January of this year to automate that review. In other words, Odyssey now includes automatically for every case a link that enables the investigator to quickly pull up that history and look at it and reflect that they have in fact done that, which is what the audit suggested. So we will see in future audits whether in fact that has been successful in eliminating this issue. In terms of training, a number of recommendations. One was that we provide regular training on our policies and procedures and the changes that have been made in that. We will do that. A second was that we continue to provide training on our Odyssey procedures and documentation to make sure that people are in fact entering stuff correctly in Odyssey, which is then the basis for all the data that we use. We did that in April of last year. We will do a follow-up training over the next 6 months or so. There were then 3 relatively minor issues that they recommended training on: requests for translation services to ensure that everybody understands that when there's a flag in Odyssey indicating that a respondent and or a complainant has requested that communication be in another language, that we in fact do that. We have provided that training. Some technical training on the interpretation and application of 2 statutory provisions relating violations of court orders, and on the interpretation and application of 1 rule regarding accounting for held property. We did that training yesterday in an office-wide training on the random audit report. So that's basically our report. Happy to try and address any questions.
All right, thank you, George. Any questions from members of the board? All right, seeing none. George, I just want to say I think that...
I have a question. I have a couple questions.
Oh, I'm sorry. Go ahead.
Thank you, George, for this presentation. I have a few questions. One is just, could you give us a sense of what percentage this audit looks at, and has that percentage of the random sampling changed over time? What does this represent?
So in any given 6 months, we will close somewhere, depending on how many cases are coming in, we'll close anywhere from probably 7,000 to 8,000 cases. So the 255 is a fairly small sample. We did recently change our sampling procedures. In particular, we set aside a specific sample for respondents who have 15 or plus prior complaints so that we could check on that. We basically take 6 respondents who have multiple complaints against them, and we look at 8 complaints for each of those. That then shrunk the sampling size on the other areas, but the sampling size is, it is a small sample, but that's also driven by cost concerns, because as we increase the sample size, the cost of each audit would increase.
Got it. Thank you. A couple of other questions. One, I noticed that in places in the write-up, let me back up. A lot of the sort of deficiencies or errors that were noted in this audit had to do with lack of documentation in Odyssey. And there were places in this report where the auditors noted that the lack of documentation didn't mean that something didn't happen, for example, right? It didn't necessarily mean that a respondent's history was not considered. It just meant that it wasn't documented. And I think it would be helpful in future audits to always have that call out to note whether it's a documentation issue or whether it was an actual substantive consideration of the case issue. And I don't know if the auditors are able to do that.
They can do that, and in the larger report, the unredacted report, typically they do advise us. So for example, if something was done and the lack of documentation and they discovered that in fact it wasn't done and it had an impact on the case, those might be the cases that they recommend for reopening, or they will note that that's occurring. A large number of the issues turn out to just be documentation issues and not actually substantive issues with the case.
Okay, great. And then my last question has to concern, in looking at page 4, not of your slides, but of the report, there is a mention in the paragraph about checklist question 9 that talks about, in that last sentence of that paragraph, 14 files were identified with substantive deficiency in the investigation, including incorrect or improper analysis of factual or legal issues, failure to address all key allegations, failure to investigate or fully investigate misconduct. And then that's again reflected in the following paragraph with respect to interactions with respondent or respondent's counsel, a failure to ask about all the allegations. And so this, I just wanted to know what recommendations flow out of this particular issue and what we can do to, what your office can do to make sure that that's addressed.
Yeah, so typically they identify, again, if the substantive issues affect the case, those might be ones that they recommend for reopening. In addition to cases that they recommend for reopening, typically they identify cases in which they recommend that we do issue review. Those are often ones, and in this instance, there were approximately 20 of those. Those are frequently ones in which they note deficiencies like this, but don't believe that those deficiencies actually affected the decision.
Okay.
Nevertheless, they will recommend that we go back and review those issues in that particular case. And we do that. And typically, we will have a discussion with the person who handled that case to address those individually if we believe it's an individual failing. Or if it's a systematic failing, we will work that into the training that we do for the office as a whole. So for example, if there's a particular issue, so to take an example from the last audit, in the last audit, the auditors identified as a substantive issue a failure to identify fee agreements that improperly denoted fees as non-refundable when they were not true retainers. Because that was more of a systemic issue, we did office-wide training on that issue to remind people of that difference and how they should apply that rule, and that was an issue that they should identify in cases if in fact it was present. So that's how we try and address that.
It struck me that this particular, I mean, to me, this is a sort of like issue of issue spotting. And it seems like something that could be addressed sometimes in the same way like the medical profession addresses these through use of checklists. And, you know, before a case is closed, making sure that the investigator goes through a checklist to be like, have you considered this and this and this and this, so that you can have it easy, like a handy reference, as opposed to making sure it's in your head, because you can easily, even the best investigator could forget an issue.
So I don't disagree with that. We can see about putting that together, and to a certain extent, it's difficult given the very large number of different charges that we have, a very large set of rules. So it's perhaps a little more difficult to put together a checklist, but we can certainly think about putting something together. We do have, when we close cases, we do have a checklist that our administrative staff use to go back and check the case to see that certain things were done, but that's not a substantive checklist. So we can see about perhaps putting something like that together. In part, that's what the form language that we put together, the sample language to use in closing letters, is intended to serve that purpose to a certain extent. By identifying a set of common issues that lead to closure that provide guidance in trying to check those. But we can see about whether we should do a more kind of direct checklist type approach.
Yeah, and I wonder whether, because there are so many issues, it could also, you could kind of collapse it, and there could be some where it's like, if yes, then go to this other document, so it's not, you know, doesn't become unwieldy.
So that's something we'll consider that and look into that.
Okay. Great, thank you.
All right, thank you for those questions. Any other questions from the board? All right, just want to thank the liaisons to OCTC, Trustees Tony and Vice Chair Cisneros, and continuing to work with George. I think this is a really important aspect of our discipline system and provides, as you heard, a lot of opportunities for continued refinement of staff, for processes, and just really, I think, exemplifies the heart here at the State Bar to make sure that we get it right. And George, I really appreciate all the work you do to make sure that happens. Moving on to item 5.4. This is a discussion regarding Rule 2201 program performance metrics, and this item is being presented by Special Deputy Trial Counsel Administrator Stacia Laguna. And so if we could promote Stacia.
Hi, good morning, everyone.
Morning.
My name is Stacia Laguna. I'm the administrator for the Special Deputy Trial Counsel program. My presentation today is regarding our first quarter performance metrics. Can everyone see the presentation?
Yes.
Okay. Some key takeaways for the first quarter were that we had a greater influx of referrals from OCTC. So our case inventory jumped up from 60 to 78. That in turn caused a change in our caseload clearance. So we are down from 119 to only 75, which is outside the target range. Complex case processing speed was within target range for investigation and overall case processing. Non-complex case processing did not meet those target ranges, but did improve from the prior quarter from 2023. Another point to note for the board is that we discovered 7 old cases that were closed in 2018 but remained open in the Odyssey system. So those were counting toward our metrics for past reporting. We were able to get those closed based on the appropriate date in 2018 when they were closed, and that resulted in a 4% drop in previously reported open backlog cases. This first slide is the major key performance indicators. Like I mentioned, there was the increase in the overall inventory, which caused a decrease in our clearance rate. In terms of quality, there were no reopens for the first quarter, which is positive. And also, as mentioned, the complex case metrics for processing on complex cases were within the target range. On non-complex cases, we didn't meet those metrics, but it was an improvement. One thing I do want to remind the board of is that because our inventory is so much smaller than that of OCTC, we are susceptible to swings due to older cases that serve as outliers. So I would like the board to take a look at the lower right here, which are some positive numbers for us. For non-complex cases, we're closing or reaching a disposition in 93% of those in the appropriate time frame. And for complex cases, it's 80%. So those are positive numbers for us. This slide is about backlog. We have the same number of cases in backlog for Q1 as we did in 2023. It represents about half of our inventory. If you look at the lower half of the screen over time, these are positive. We're moving in a positive direction as far as our percent of cases in backlog. It's down from mid-year last year. And if we project that over the whole year, we're looking to have some positive numbers at the end of 2024. It's projected that we would have 16 cases in backlog and only 8% of our inventory if we stay on target. These show our case inventory and case age. So showing here, we closed 49 cases in the first quarter. And down here showing we had the influx of 65, or we had the 65 incoming cases. So that shows the downward departure in our overall clearance rate. Taking a look at case age at closure, though, these are positive numbers for us. The case age is down from the prior quarter. The lower right is the makeup of our cases overall. The blue is the cases less than 6 months old. We have very few that were in the 6 months to 1 year range. And then we have the 29 that were in backlog status for Q1. This shows our case passing through each phase. We had just over 50 going through intake, just over 20 going through investigation. And in Q1, we filed 1 case. On the right side of the screen, duration of cases at each phase in days. We have very positive numbers for intake. I think it's about 20 on average, 20 days on average in the low 20s. And then the median number is 12. Investigation, pretty steady from prior quarters. The average duration was 290 days. The median was 165. So the median is within our target range. And this final slide is about quality. Like I mentioned, we didn't have any reopens on our second look procedures, which is our function of crew. And our audit for this year is ongoing, so nothing to report for Q1 for random audit reopens. With that, I'll take any questions.
All right, thank you, Ms. Laguna. Any questions? Yes, Trustee Barahona.
Thank you, Mrs. Laguna, for the presentation. Really appreciate it. Is what led to the case inventory increase related to the older cases that serve as outliers? Is that what has led to that specific increase?
No, the increase represent new referrals from the Office of Chief Trial Counsel. And at the beginning of this year, we had one particular complainant that complained against many attorneys, and all of those were conflict cases. So it's not something that we expect to see repeated over time, but it's something that can happen when we have one complainant submit a number of complaints.
Understood. And so that then decreases your case processing time and gives you a number that's actually not reflective of what's happening.
Right, our case clearance rate, yeah. So ideally, we'd like to have a 100% clearance rate, meaning for every case that we get, we are reaching a disposition in another. With that large influx and with our staffing being the exact same, we have the decrease down to 75%.
Thank you so much. And then my second question just is, to what extent have we considered the use of AI or a particular, protected AI platform? I assume you're going to say there's a significant amount of nuance and specialization required, but I'm just curious about the interest or assessment in AI to expedite some of the cases.
Yeah, that's an interesting question. Typically in our program, we do our best to mirror what OCTC does and keep our processes as consistent as possible within reason, given that the nature of our program is a little bit different, but we are doing the same work as OCTC. It's just on a smaller scale, and our structure is different because we use outside private attorneys. So I would defer to OCTC's lead on that and the direction of the board.
Thank you so much.
All right, any other questions or comments?
I will just say we're going to talk about the use of AI in the State Bar, including for disciplinary case processing tomorrow.
All right. Special thank you to our Rule 2201 liaisons, trustees, Chin and Huser. So thank you for keeping us up to date on that. And Ms. Laguna, thank you for your excellent work in this area, for keeping us well informed. And as always, if you need any more resources or anything else, please do not hesitate to bring those requests before us.
Thank you. I appreciate that.
All right, moving on to item 5.5, keeping it fresh with some more rules. We have proposed amendments to Rules 2.2, 2.11, 2.16, and 2.71 of the Rules of the State Bar, and Rule 9.31 of the Rules of Court relating to attorney reporting and the timing of the annual renewal cycle. And this is a request for public comment, so everybody can breathe a little bit easier. And then here to shepherd us through is Special Counsel Steve Moawad. Welcome back.
Thank you. Thank you very much. I will keep my comments very brief. There are essentially two changes. The purpose of this is to make two changes. One is to clarify reporting requirements of attorneys around law firm size relevant to Rule 2.2 of the Rules of the State Bar. And the other is to permit the State Bar flexibility around the deadline for the renewal cycle. And this is in conjunction with legislative changes that we are also seeking. The one complexity is around 2.71, and that is because that is also on the consent agenda. So if the item on the consent agenda gets passed, then attachment G would be distributed, and if not, then attachment I would be distributed. But that's why there's the extra attachment, was to cover whatever the board chose to do on the consent agenda. Got it. And I'm happy to take any questions.
All right, thank you. Any questions or comments? Okay, seeing none, Madam Secretary, can I have the resolution placed on the screen? All right, so this is a resolution to put out the rules for a 60-day day public comment period. And after trustees have had a chance to review that, if I could have a first and a second.
I'll move the item.
I'll second.
I think I heard trustee Huser get in there with the second. All right, so we have a first by trustee Tony, second by trustee Huser. Madam Secretary, can I have a roll call vote, please?
Barahona,
Aye.
Buenaventura,
Aye.
Chen,
Aye.
Cisneros,
Aye.
Good,
Aye.
Grande,
Aye.
Huser, Shelby,
Aye.
Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo, not present, Stallings.
Aye.
It's 12 ayes, 0 nays, motion carries.
All right, thank you. And going to item 5.6, this is a proposed amendments to Rule 2.31 relating to the deadline for submission of the transfer to inactive status form and the effective date of the transfer. This is, again, a request to circulate for public comment, and Mr. Moawad is here to help us.
Thank you. This rule amendment, if adopted, would require that to be eligible for the inactive rate the following year. The transfer to inactive form must be submitted by December 1, and the effective date on that transfer to inactive form must be on or before December 31. There's a couple of benefits that I'll go over quickly. The first is that because the rule currently says that it must be submitted by February 1st, as I'm sure you can imagine, we get a lot of requests around February 1st, January 31st and February 1st. And what that requires, because we've already set up the billing, is that it requires us to go back and redo the billing, change the status, redo the billing, and then reach out to the licensee saying they can now pay the reduced rate. So if we could do that before the billing is done, that would save us a bunch of time. And those requests come in during the busiest time of our year, which is the renewal cycle. Another explanation is that the license fee is for a calendar year. So it makes sense that if they're not going to pay for the active rate for 2026, for example, that they are not in active status in 2026. And finally, not directly related to the fee cycle or to fees, but the CTAP is also related to the calendar year and must be reported on the calendar year. And many people who go inactive on January 31st or February 1st forget that they were active during that year and then get into trouble with CTAP because they failed to report. So having them go inactive in December would resolve that issue and prevent people from getting into trouble with CTAP.
All right, great, thank you. Any questions or comments? Yes, trustee Tony.
Please remind me CTAP.
The Client Trust Account Protection Program. Sorry, I speak in jargon sometimes.
All right, anybody else? Okay, seeing none, can I have the resolution put up on the screen?
One other thing I should point out is that we are requesting that this be sent out for a period of 45 days instead of 60. That will enable us to bring it back before the board to reap the benefit of this renewal cycle.
Definitely, that is well received. Okay, after trustees have had a chance to review the resolution, can I have a first and a second, please?
So moved.
Is that trustee
Second.
Sewell? No. I'm sorry, who did the first?
Stevens.
Okay, sorry about that. Trustee Stevens with the first, and then who did the second?
That was me.
Okay, trustee Barahona. Okay, sorry about that. Okay, unless there's any further discussion, may I have a roll call vote?
Barahona,
Aye.
Buenaventura,
Aye.
Chen,
Aye.
Cisneros,
Aye.
Good,
Aye.
Grande,
Aye.
Huser, Shelby,
Aye.
Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo not present, Stallings.
Aye.
12 ayes, 0 nays, motion carries.
All right, thank you, Steve. Item 5.7, proposed amendments to rules of procedure regarding remote appearances in state bar court proceedings. This is Rule 5.17 and 5.18. This is a request to circulate for public comment and request for interim adoption of rule changes. This item is being presented by Projects Attorney Kathy Sher. So if we could promote Ms. Sher, and, oh, there you are.
All right.
Welcome.
Thank you. Good morning. The State Bar Court proposes some small but critically important changes to Rules 5.17 and 5.18 of the State Bar Rules of Procedure. These changes are essential to allow the court to continue to manage its calendar efficiently and to minimize delays as we move to having only one courtroom for 2 judges in our San Francisco location. Let me start with what the current rules do. Under Rule 5.17, the default for any proceeding in the State Bar Court that is not a trial or evidentiary hearing is that it will be held remotely, with the parties appearing by Zoom. Under Rule 5.18, the default for trials and evidentiary hearings is that the parties will appear in person. When a party wishes to appear in person for a non-trial proceeding or remotely for a trial, the party must provide written notice to the court and the opposing party. For trials, the opposing party is given the opportunity to oppose, and the court then makes a determination whether to allow the remote appearance. Under Rule 5.18, a party has 10 days from service of the notice of the trial date to file a notice of the party's intent to appear remotely. The opposing party then has 5 days after that, either to state that party's intent to appear remotely as well, or to oppose the remote appearance. The result is that the court often does not know until shortly before trial that both parties intend to appear remotely. This is frustrating now, but when the court only has one San Francisco courtroom, it will likely lead to unnecessary continuances when there are apparent conflicts of what the court expects to be in-person events, but in fact will be entirely remote proceedings. The proposed changes will simply make it easier for the parties to give advance notice of their intent to appear remotely for trial. The amendments will allow a party to give oral notice at the initial status conference, allow the parties to stipulate orally at the initial status conference, or will allow the parties to file a written stipulation with the court within 10 days after service of notice of the trial date. These changes will, in many cases, give the court advance notice that the trial will be held entirely remotely, allowing the court to better manage its calendar and the scheduling for the one remaining courtroom in San Francisco. The parties will benefit as well by having more options for giving notice of a remote appearance and being able to do so without having to file a written notice. There are some further changes that are largely cleanup and getting rid of some unneeded provisions in the rules. Because the court will lose courtroom to sometime in August, we are asking for interim adoption of these changes while they are circulated for public comment. And I'm happy to answer any questions you might have.
All right. Thank you, Ms. Sher. Any questions or comments from the board? Okay, looking at our remote attendee pool, not seeing anything here in the room. Can I get the resolution put up on the screen? All right, after you've had a chance to review, actually, sorry, let me ask this. How long is the public comment period?
45 days.
Okay. All right, this is a request to send out for 45 days. Can I have a motion?
Stevens, so moved.
Second.
All right, first by trustee Stevens, second by trustee Grande. If there's no further discussion, may I have a roll call vote?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, Trustee Chen stepped away. Cisneros?
Aye.
Good?
Aye.
Grande?
Aye.
Huser? Shelby, Trustee Shelby also stepped away. Stevens?
Aye.
Soel?
Aye.
Tony?
Aye.
Trejo, not present. Stallings?
Aye.
It's 10 ayes, 0 nays, the motion carries.
All right, thank you. And moving on to item 5.8, this is the proposed new rule of procedure regarding vexatious litigants in State Bar Court. This is, again, a request to circulate for public comment. And we have Ms. Sher presenting on this as well.
Yes, thank you. So this item asks for approval to circulate for public comment a proposed rule to help the State Bar Court deal with the problem of vexatious litigants. The rule is essential to allow the court and the State Bar to effectively fulfill the mission of public protection without wasting resources. I'm going to start by giving an overview of the problem, describe what the proposed rule will do, and then explain how it will help address the issue. Vexatious litigants are those who abuse court processes. In state and federal court, the problem is often litigants who repeatedly file meritless lawsuits. In the State Bar Court, the problem generally takes the form of litigants who over and over again seek to relitigate issues that have already been finally determined, who file the same pleading, sometimes exactly the same pleading, multiple times with the court, or who file frivolous motions and other pleadings solely for the purpose of delay, and who file hugely lengthy pleadings and attachments, sometimes thousands of pages, largely made up of irrelevant materials. Each filing requires the clerk to review to determine if the pleading meets the requirements for filing, and then to take time to process and file the pleading. Staff attorneys must review the entire pleading and all attachments. The opposing party, often OCTC, must take time to respond to what is often a frivolous motion, and then the court must hold a hearing and make a decision. To give one example, the State Bar Court has had a case in which, in the course of the first 2 years of litigation, the respondent filed 4 motions to dismiss, 9 motions to disqualify judges in the case, 6 motions for reconsideration of rulings, and 7 petitions for interlocutory review of rulings, which were heard by the State Bar Court Review Department. Some of these pleadings were accompanied by hundreds of pages of attachments. An enormous amount of time is wasted processing all of these motions and petitions, which are generally just denied in the end. All of this takes time away from other cases where there are issues that legitimately need to be resolved and slows down the disciplinary process for everyone. In the cases involving vexatious litigants and in other cases delayed because of the time spent on those cases, additional harm may be caused to clients or the public while the process drags on and discipline is delayed. The proposed rule is based on California's vexatious litigant statute, which is modified for the way the problem presents in the State Bar Court. The rule sets out the criteria for designating someone as a vexatious litigant. They must have either repeatedly attempted to relitigate an issue that had been finally determined, have repeatedly filed unmeritorious pleadings or engaged in other abusive litigation tactics, or have previously been found to be a vexatious litigant in any state or federal court. The rule then sets out the procedures for declaring someone to be a vexatious litigant, which can be done on the court's own motion or on the motion of a party. The litigant is given notice and an opportunity to respond to the motion, and the court may, in its discretion, hold a hearing or may decide on the basis of the documents submitted. The order declaring someone to be a vexatious litigant can impose whatever restrictions the court finds necessary to control the litigant's conduct, including, when appropriate, a requirement that the litigant get pre-filing approval from the court before submitting pleadings for filing. We expect that this rule will be used rarely. We do not see many litigants who engage in the types of abusive tactics the rule will address. But those few litigants create an enormous drain on the court's resources. We ask for the rule to be sent out for public comment so that we can move towards addressing this problem. And I'm happy again to answer any questions.
All right, thank you for that. Any member of the board have a question or comment? All right, checking our remote attendees, not seeing anybody, and no one here in person. Madam Secretary, can I have the resolution put up on the screen? All right, again, this is a request to put this item out for a 45-day public comment period. You've had a chance to review. If I could have a first and a second, please.
I'll make the motion.
Sarni, I'll second.
Okay, first by Trustee Good, second by Trustee Sewell. No further discussion. May I have a roll call vote?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, stepped away. Cisneros,
Aye.
Good,
Aye.
Grande,
Aye.
Huser, Shelby, stepped away. Stevens,
Aye.
Sewell,
Aye.
Tony,
Aye.
Trejo, not present. Stallings.
Aye.
It's 10 ayes, 0 nays, motion carries.
Thank you. Next up is item 5.9. This is proposed amendments to rules of the State Bar relating to progressive discipline. This is standard 1.8. This is a return from public comment and a request for adoption. And Ms. Sher is also presenting on this.
Thank you. So this is my final item before the board this morning. This item seeks the adoption of changes to standard 1.8 of the standards for attorney sanctions for professional misconduct following the circulation of those changes for public comment. The changes will give the judges of the State Bar Court greater discretion in applying a policy of progressive discipline. This is an item that came out of the recommendations of the ad hoc commission and then was worked on by a working group within the State Bar Court. I'm going to start by giving a quick overview of the policy of progressive discipline and the reasons that the proposed changes is proposed, summarize the comments that were received, and then discuss why we believe the adoption of the changes is appropriate. As a refresher from when this item came before you in March, progressive discipline is the policy that requires that when an attorney has a history of prior discipline, the sanction in the current case must be greater than the sanction that was previously imposed. The current language of standard 1.8 requires the application of this policy with exceptions allowed only if certain narrow criteria are met. The Ad hoc Commission on Discipline found that this strict application of progressive discipline was contributing to the perpetuation of racial disparities in the discipline system and directed that staff explore modifications to give the State Bar Court greater discretion. The State Bar Court's working group on this issue drafted proposed changes to change the language of standard 1.8, changing the word must to should, and allowing consideration of any circumstances that would make imposing greater discipline in the current case unjust. The proposed language will also require that the judge state the reasons whenever progressive discipline is not imposed. The proposal was circulated for public comment for a period of 45 days, and 8 comments were received, 5 in favor and 3 opposed. Those opposed to the proposal raised the concern that allowing greater discretion would lead to weakened enforcement of disciplinary standards against repeat offenders. One comment in particular said that this would, quote, open the door to another slew of Tom Girardi type incidents. Certainly, there's a valid concern as to ensuring that those who engage in repeated misconduct face sanctions that are adequate to deter further wrongdoing. However, I want to note that the proposed changes still leave in place a generally applicable policy that the discipline in the current case will be more severe than the previously imposed discipline. It gives judges the flexibility to look at all of the circumstances of the current and prior case in determining whether to make an exception. The working group at the State Bar Court that developed this proposal believes that this strikes the right balance between ensuring adequate sanctions for repeat offenders and giving judges the discretion they need to achieve a just result for a particular case. So we ask for your approval of the proposed amendments to standard 1.8. And again, I'm happy to answer any questions you might have.
All right, thank you. All right, any questions or comments? Trustee Buenaventura.
Yes, thank you, Mr. Chair. Ms. Sher, could you, it was good that you were able to highlight some of the comments, but could you also highlight what the comments were in favor just so we have a clear understanding of the public of what was the comments that were in favor of this change.
Yeah, so there was one comment in favor, and let me just pull up my comment chart. I know that there was one comment in favor that specifically referred to giving the flexibility to address the issue of disparities. Apologizing. There it is. Okay. And I know there was also at least one comment in favor that did not make any specific comment, but simply, so let's see. One very long comment, and so it's taking a little time to flip through to find the other ones. Yeah, so we had one comment in favor that said, thank you for addressing past inequities in discipline by granting judges more discretion. And then I think we had a couple of comments in favor where the substance of the comment was not particularly relevant to the proposal. And I believe we had at least one where, as I say, there's no substantive comment, but just indication that they.
Great, thank you, Ms. Sher.
All right, thank you. Any other questions or comments? Okay, seeing none, I would just say that, you know, I received the public comments and their concerns about granting greater discretion, and I think absolutely whenever you have a rule that provides for discretion, there's opportunity for, you know, for different outcomes. However, I do believe that this rule does strike that balance in providing the court with some guidelines, and I think does provide pretty good rails for such a discretionary decision to be made. So I'm in support. I would ask that our secretary put up the resolution. And so this is to adopt the proposals after trustees have had a chance to review. If I could have a first and a second.
I'll make the motion.
I'm going to receive trustee Goods first and then trustee Buenaventura as the second. And if there's no further discussion, I'll have a roll call vote.
Okay, just to confirm, that was trustee Good with the motion and trustee Buenaventura with the second. Okay, thank you. Barahona?
Aye.
Buenaventura?
Aye.
Chen? Not present. Cisneros?
Aye.
Good?
Aye.
Grande?
Aye.
Cuser?
Aye.
Shelby? Believe. Do see trustee Shelby is in attendance, but may be away. Okay. Stevens?
Aye.
Soel?
Aye.
Tony?
Aye.
Trejo, not present. Stallings?
Aye.
It's 10 ayes, 0 nays. Motion carries.
All right. Thank you, Ms. Sher, for your work on everything. Really appreciate it.
Thank you.
All right, item 5.10, this is a proposed amendments to rules of the State Bar regarding the Lawyer Assistance Program. This is a request to circulate for public comment, and this item is being presented by Program Director Melanie Lawrence. So welcome, Ms. Lawrence.
Good morning. Joining me today is Michelle Herman, the supervisor of the Lawyer Assistance Program. This item requests that the board release for a 60-day public comment period proposed amendments to the Lawyer Assistance Program rules. The LAP Oversight Committee has spent the last several months reviewing the rules and crafting proposed amendments that will reflect the actual services of the program, that will simplify and focus the rules and that will change the form of financial assistance from a loan to a grant. There has been no significant update of the Lawyer Assistance Program rules in several years. As a result, the rules are programmatically outdated in that they describe services that are no longer offered. So these proposed rules would reflect the current services that are offered. It also adds definitions for key terms, clarifies confidentiality of LAP records, and clarifies the monitored program of the Lawyer Assistance Program as well as the Support Services Program. And also importantly, related to financial assistance, the proposed rules will clearly state that the Oversight Committee is responsible for establishing criteria for eligibility for financial assistance. That is that participants in the monitored program who are eligible may receive financial assistance. Ensures that the criteria will be publicly available on the State Bar website. And again, it does propose to change the financial assistance from a loan to a grant. Historically, there has been very little that has been collected from folks who have received the loan, and as a result, there is a significant amount of uncollected debt. There is no statutory authority for the bar to collect on that debt, and so practically speaking, the program has been operating as a grant for a number of years. However, the committee does recognize how important financial assistance is for some participants with modest means who are at very vulnerable points in their life, struggling with mental health and substance use issues, and therefore wants to convert the loan to a grant. It also incorporates language from the statute that the total grant amount cannot compromise the administration of the program. So again, we're asking that this be sent out for public comment, and we're happy to answer any questions that you have.
All right, thank you. Any questions? Yes, Trustee Tony.
You know, what I'm curious about, and the resolution is fine as it is, put out for public comment, is if consideration has been given to, and maybe this proposal has it. I get the going forward, okay, changing into a grant, and I think that makes sense. I like the idea of figuring out what do we do with with this proposal, what does it do with the past debt? Just clarify that for me.
Well, as proposed, it doesn't change the past. So for those folks who received a loan, theoretically, they're still obligated to the bar to pay it back.
Okay. And this can be for further discussion when it comes back, but it's the way I think there are two choices, and I think that the full resolution should address the back debt, especially when you're changing it from a loan to a grant. And I would suggest one of two things for us all to think about as a Board of Trustees. Do we want to have you know how it is with the public libraries will have a little day where, it's forgiveness, or, something where look, if you pay 10% on the loan, it'll be forgiven for 10% payment. It just, or to say, we're just gonna zero everybody out. But, my opinion is that debts should be addressed one way or the other, and there's no point to letting debts sit on the books for decades, because it's just not good accounting practices for one thing. So anyway, those are just thoughts of mine.
I think it's a great point, and we can certainly look into whether or not we can just waive all of that outstanding debt by the time this item comes back. Because this debt, we aren't even able to collect on it the way that we are some of our other debt.
All right, thank you for that question. Any other questions, comments? I just had a couple of questions. One is, has there been any study regarding the correlation of an individual who either pays the loan or does not pay the loan, and then any sort of recidivism in the future?
I'm not aware of any, no.
And I guess not just recidivism, but successful completion of the LAP program.
There's not been any study of it. However, the loan doesn't come due until the person leaves the program. So, so it would not affect anybody's ability to successfully complete whether they had or had not yet paid back their loan.
Okay.
But we have looked at successful completion of at least ADP and recidivism. Yes, we provided that to the board some years ago. So certainly we have done that in the past.
Right. A number of the folks who receive financial assistance may never have been involved in the discipline system, however.
Okay. All right. Any other questions? Comments? All right, looking to our remote attendees, seeing nothing. Here in person, seeing nothing. Can I have the resolution put up on the board? All right, and this is a request to circulate for 60 days. After you've had a chance to review, may I have a first and a second?
I'll move the item.
I second.
All right, first by trustee Tony, second by trustee Grande. If there's no further discussion, may I have a roll call vote?
Barahona,
Aye.
Buenaventura,
Aye.
Chen, not present. Cisneros,
Aye.
Good,
Aye.
Grande,
Aye.
Huser, Shelby, not present. Stevens,
Aye.
Soel,
Aye.
Tony,
Aye.
Trejo, not present. Stallings,
Aye.
10 ayes, 0 nays, motion carries.
All right, thank you so much. Item 5.11, this is request for approval of mandatory fee arbitration filing fee increase. And this item is being presented by Melanie Lawrence.
Thank you. So this item seeks board approval to raise the filing fees for the mandatory fee arbitration program. And the mandatory fee arbitration program is typically used when a client is disputing their attorney's fees. The attorney must participate in the fee arbitration program if the client elects it before they could actually pursue civil litigation to recoup attorney's fees. This item was initially on the May board agenda for approval, but instead it was presented as a discussion item. And that is because after posting the item in May, the LA County Bar Association raised concerns with us that by raising these fees, local MFA programs may follow suit. And it appears that the concern is that if they were to do that, that less people would avail themselves of the program. So the state bar provides an MFA program, typically speaking, where there is no local program available. So there are a number of local bars that provide MFA programs. They have their own rules and their own fees. They do have to be approved by this board, however. So I think that the concern is that our rules may serve as a model for others. So the concern is that they may follow suit, and that as a result, people will be less likely to participate in fee arbitration. So since the May board meeting, what we did was we surveyed local programs, and the survey is attached as attachment B to this item. And we asked those programs, if the state bar were to increase filing fees, did they think that it would impact their program in any way, and to explain. We received 9 responses. Of those responses, none of them, other than the LA County Bar Association, indicated a potential negative impact. And that is, again, that no one will use the program and that it may sour parties on the use of mandatory fee arbitration. And also, there appears to be a concern that this is driven by an intention to profit. You may recall that one of our assistant presiding arbitrators, we have two, gave public comment. Mr. Strauss gave public comment in opposition of this. He's been a long time advocate of our program, very passionate about fee arbitration, and we very much appreciate his commitment to our program. But we are frankly in a situation where this program operates at a significant deficit. And while it is true that it was originally motivated by the State Bar's recommendations in October 2023 that the State Bar is to identify programs that do not fully cover the costs of the program, that those service fees be increased, unless doing so would limit the public's access to the services. So that is originally why we were looking at this, but again, the fact of the matter is it operates at a significant deficit. We spent last year making modifications to the program to bring about more efficiencies, and the revenue for the program is based entirely on filing fees, which for 2024 budgeted at $100,000. Operational costs are significantly more and resulting in a structural deficit of close to $700,000. So we know that an increase to meet all of our costs would likely limit public's access, and we don't want to do that. So the proposal rather seeks to close the gap somewhat. The proposal will generate a 32% increase in annual revenue. There still will be a structural deficit, however, of just over $400,000. We are mindful about the impact of the public on increasing the fees. So to lessen the impact on the public generally, we have structured it, in particular related to the maximum fees. So the proposal is to increase the fees across the board from 5% to 6%. Now, it's determined by the disputed amount. So that's the percentage that it's determined by. To raise the minimum from $50 to $100 and to raise the maximum from $5,000 to a tiered approach. So no one will pay more than $20,000 under the tiered approach, and it's attachment A. So even if you have a dispute that's over $500,000, for example, you're still only going to pay $20,000. Now, I just want to note that the majority of our cases are below $100,000. So those folks will still continue to pay a maximum of $5,000. In 2023, we had 7 cases that were over $250,000, and 1 exceeded $500,000. It not only exceeded $500,000, but it was a multi-million dollar case.